Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. Today, I'm doing an update video. Hopefully, this won't be very long. Just to kind of give you guys a temperature check on some of these cases. Following a lot of cases right now, of course. And I don't want you guys to think that some of these cases are getting lost in the miasma of stuff that's being covered. And I want to just kind of give you a general update on where they are, because court moves slow. And so I don't want you to think they're being forgotten. They're not being forgotten. It's just that sometimes there's not much to say about them. So first, Poppy. There is an update, a very mild update in the Mars Argo versus Poppy and Titanic Sinclair case, in the fact that Mars Argo and Titanic Sinclair did have a hearing scheduled for this morning, well, the morning of the 22nd at 8:30 a.m. And that hearing was continued again until next month. So no news on whether or not Brittany Sheets will have a restraining order against Corey Michael Mixter. I think last time it was Mixter who requested the continuance. This time it was Sheets. For whatever reason, Sheets has decided that she wanted more time, so the court gave it to her. In the news of the Poppy copyright case, Poppy has still not been served. Neither has Corey Mixter, nor either of their respective LLCs. None of them have been served. Sheets has not served anyone in that case. And, at any time it could be dismissed by either the judge or by any of the parties. I still think Sheets is waiting to get a restraining order against Mixter. And that restraining order she will then use to bolster her claims of the abuse, and probably try and use that restraining order as evidence that the copyright has taken place. It doesn't legally work that way, but it can work that way in the minds of a fact-finding, judge or jury. So that's where Poppy sits. No real news, but I gotta let people know because people ask me about it all the time. Next, surely you have heard that Cohen, the attorney for Donald Trump, has pled guilty to several criminal acts, and some acts that may not actually be criminal acts. And I want to lay this out there because some people think that just because... Why is this tilted? That's a little better. Sorry about that. Some people think that just because someone pleads guilty to something, that they're actually guilty of a crime. And if you think in that sort of way, I've got news for you. People plead guilty to things that they're not guilty of all the time. All the time. And federal prosecutors and state prosecutors prosecute people for things that might not even be criminal acts all the time. There are actually people in jail for pleading guilty to things that are not criminal acts. And that sounds really weird, okay? But let me lay it out this way in this particular context, all right? Now, a lot of the Cohen stuff, he definitely appears to be guilty on, and it's very clear-cut. Tax evasion, bank fraud, stuff like that. And that's his deal to deal with, right? The thing that most people are focusing in on is the fact that he pled guilty and alleges that Trump is involved to making illegal campaign contributions in the form of one payment to Stormy Daniels and one payment to a newspaper that was going to cover the story of this other person, who both Stormy and this other person allegedly had an affair with Donald Trump. Okay? So, Cohen has said that Trump directed him to make an illegal campaign contribution in the form of making payments to these people. here's the kicker. It's not actually clear that payments settling disputes from accusers of various things is actually a campaign contribution. Okay? So, and don't take my word for it. Just go read some different opinions. No one really knows for sure whether or not this is a crime, or that this would be a violation of federal election law, I guess is a more appropriate way to put it. In any context outside of an election, paying Stormy Daniels or paying, and Trump using his own money, for example, to pay Stormy Daniels or to pay off this this newspaper that was going to run a story about him, would not be a criminal act in any way. In any way outside of an election. You can pay people to not talk all you want. That's non-disclosure agreements, take all sorts of forms. You can do them all day. If you want to just throw money at people and say, hey, you can't ever talk to anybody about this anymore, and I'm going to give you X amount of dollars, and they agree to it, that's fine. That's fine. Okay, so that is an okay thing. Some people are alleging, however, that these payments were made in an attempt to influence an election. Because the tangential way to get there is that if these stories came out, people would react negatively to them, and so suppressing them is influencing an election, and basically it acts as advertising. That's a tenuous theory on federal election law, because people do stuff like this quite often. And it will really depend on what the money, where the money came from, how the money was paid, who it was paid to. And a lot of it might just look like a personal expense rather than a, a campaign expense. And the trick to this is that if this money was paid out of the campaign, that very well might be an illegal use of campaign funds to pay personal expenses, right? We've seen actually several people recently charged. The politicians, Duncan, I think, is one of them. They're paying personal expenses out of their campaign funds. They get tagged for it. That's a violation of federal election law. Outside of the context of the election, there would be no doubt that these are personal expenses. So the question is, how clear is it that these things have morphed from a personal expense to a campaign expenditure, and therefore making those campaign contributions illegal? Now, Cohen has pled guilty to making an illegal campaign contribution. The rub might be that he didn't make an illegal campaign contribution. However, he has pled guilty to that crime and admitted a factual basis sufficient for a judge to find him guilty, which would be President Trump directed me to pay X amount of dollars to this person as a campaign contribution to influence an election. That's the sufficient factual basis. That doesn't mean the legal analysis is correct. It might be. It might be. My point is that people don't actually know. And it's important to remember that Cohen pleading guilty to this crime in no way actually legally implicates Trump in the crime. All right? Because Trump still has several defenses available to him. One, this isn't a criminal act. That's one big defense that the prosecutors would have to overcome. Had Cohen gone to trial, he could have forced them to overcome it. He didn't go to trial. Why? Because they nailed him on bank fraud and they nailed him on the tax evasion. If he's got bank fraud and tax evasion, the way it works, as I understand it, in the Southern District of New York, is you plead guilty to all of the crimes that you're charged in a guilty plea. That's just how it goes. That's not how it goes in every district. In some districts, they will drop charges. In other districts, you'll plead to specific charges or just one charge or something like that. Anyway, the reason Cohen doesn't go to trial on those issues is because they've nailed him on these things. So it's in his best interest to negotiate a plea settlement and to mitigate and minimize the amount of punishment he's going to get by offering evidence to the prosecution that will be helpful for whatever ends they have. That's that. That might mean that Cohen pleads guilty to a crime that's not a crime. And again, if you are in the camp of people who don't think people in jail are innocent, or who don't think there are lots of innocent people in jail, I've got news for you. Tons of them. Our jail system is bad. Our justice system has problems. It's not saying there's a whole bunch of better solutions out there, but innocent people go to jail. Sorry to break that to you. And Cohen appears to be guilty on several things. Don't mistake me for saying he's not. But the campaign stuff does not necessarily implicate Trump. That is a separate legal question. He has several legal defenses. We don't even know if he can be indicted. Expect this from the Cohen decision to plead guilty. This story will run through the November elections in an attempt to influence midterms. And isn't that great? How much did Cohen just pay for that, right? Like, there's another illegal contribution right there. Anyway, moving on from that. Also, former campaign manager Paul Manafort has been found guilty at trial. 8 of his 18 counts, 18 charges levied against him. None of them actually involved the Trump campaign or anything about it. It's all for work that happened years before he was hired on the campaign. And there are lots of guys like Paul Manafort in Washington, D.C. There are lots of guys who have this type of dirt and would be very guilty of the same crimes. So I do want to point out that the Manafort conviction is bad for Trump in the public light, but doesn't legally implicate him in anything either. So you'll see a lot of people defending Trump, and you'll see a lot of people condemning Trump based on what happened in court today. Legally, those things don't matter. In the court of public opinion, which is actually where everything matters when you're talking about a president, because they may not be able to be criminally indicted during their term of office. What really matters to a president is what's going on in the court of public opinion, okay? In the court of public opinion, Trump had a very bad day. All right, next, Russell Greer has served Taylor Swift. So now Taylor Swift has to respond to his absolutely ridiculous lawsuit. You can expect a Rule 12b-6 motion to dismiss for failure to state a claim. You can expect Taylor Swift to demand that Russell Greer be forced to pay her legal fees. You can possibly expect a restraining order based on the idea of malicious litigation and harassing litigation against her. That should be coming. I will be watching out for it. As soon as it comes, I will, of course, go through those documents. Next, Alex Jones has 2 defamation cases that are kind of running in tandem, and he also has the Pepe case. The Pepe case has a scheduling conference, I believe, next month. Excuse me. So be on the lookout for Pepe updates. The defamation cases, they're in this weird procedural limbo. They were filed in Connecticut State Court, and then the defendants moved to remove that from the state court and send it up to the federal district court, which is why I'm easily able to get the documents through the federal government's tracking system, PACER. Okay. Now, the plaintiffs, the people alleging the defamation in both of those cases, have moved to remand the case back to state court because they say that one of the defendants is a Connecticut resident. Therefore, if you don't have complete diversity jurisdiction, that's where all the parties are from separate states. All of the plaintiffs are from separate states from all of the defendants. If you don't have complete diversity jurisdiction, a claim can be brought back to state court. That's what they're trying to do. However, the one guy from Connecticut seems to be the most tangentially involved of all the defendants. He has moved to dismiss all charges against him, and that dismissal may have a pretty a pretty big impact on how the procedure goes from here on out. So that's you know, until that happens, kind of in limbo there. As for Cody Wilson's case, Cody Wilson being the Ghost Gunner Defense Distributed Second Amendment Foundation, his case there's been a new motion to for a temporary restraining order brought by even more attorneys general. And when you get this many lawyers involved in a case, the documents are really, really long. They filed a 266-page declaration. Thanks, guys. I'll be going through that when I can. But the main news I have in that case is Cody has stated on Twitter that he will do an interview with me, and I'm just waiting for him to give me a date. Once we have a date, I will do an interview with him. He wants to, what he's indicated to me, do a technical legal interview. So we're going to be talking about some nitty-gritty legality involved in what's going on. I'm planning to thoroughly research the case in advance so I can understand the arguments that are coming out, to raise questions that are appropriate for that. So be on the lookout for that. He has said he's going on full offense, and I just grabbed his answer to the lawsuit just before making this video. So I'll be going through that as well. We're gonna get into the weeds with Cody Wilson, so that should be fun. Very much looking forward to it. Finally, James Damore's case. They have issued. There's a new document, couple new documents. One that's important. Excuse me. And that is the joint case management statement issued. It's joint, so it's issued by both the defendants and the plaintiffs. The plaintiffs have basically said that they do not intend at this time to name any of the 10 John or Jane Does that they reserved. They don't know of any defendants that would further fit into the lawsuit that they have raised. They're considering amending their first amended complaint to be a second amended complaint and include some additional claims under the Private Attorney General's Act, Labor Code, Section 2698 and following. The defendants oppose that. They think that won't happen, but we'll have to see whether that would work or not. Discovery. Excuse me. I'll just read it for you. They're waiting for an order from the court to initiate discovery because the court has stayed discovery. So it'll be up to the court to say, go ahead with discovery. Plaintiffs state that subjects on which discovery may be needed include the size and composition of the putative class and subclasses. So that's going to be demographic information about Google employees. Correspondence between and among the defendant, its employees, and the putative class members. That's going to be a lot. That's going to be emails, messages, recorded conversations, any of that, letters, anything. Documentary evidence pertaining to defendants' employment practices and policies. That's going to be, any sort of training videos. That's going to be training manuals, stuff like that. And deposition of defendant regarding the same. So they're going to demand depositions of the defendants, of the executives of Google. And that could be very interesting. I'm sure those would be very short depositions. The defendants, Google basically, state that discovery should be stayed pending the resolution of defendants' motion to compel individual arbitration of the claims, demur and our motion to strike the first amended complaint. Let's see. So yeah, one of the remaining issues for them is arbitration. In all of the plaintiffs' employment agreements, there's a binding arbitration clause which says that any of the claims related to their employment with Google would have to go through arbitration, not through district court. I'm not positive, But if I had to guess, the argument for the plaintiffs will be that a binding arbitration clause, which removes their ability to to bring a discrimination claim in violation of state and federal protection under the 14th Amendment, would be an unconscionable provision against public policy. They'll say this is not, this is not a dispute over a contract or something like that that would fit in arbitration. These are claims that merit the state's involvement. These are serious constitutional questions under the Constitution of California and the Constitution of the United States. These are questions that need to be resolved in the court system, not in an arbitration system. And because they involve discrimination, I think that's a very strong argument. We'll have to see what else they make, but I think that that might do it. That they would say that an arbitration clause requiring requiring arbitration over alleged discriminatory hiring practices would be unconscionable and against public policy, and therefore it should be ignored in this context. Let's see. We've got a statement from both of them summarizing their positions. That's about it. I mean, so that's where we are there. They had this case management conference, or they have, what is it? Hold on. I think they have scheduled a case management conference at court to discuss this statement. Let me just pull it up real quick. Yeah, the further case management conference is October 19th, 2018. Guys, this is going to be a long case. This is a big case, class action, high profile. Big law firms are involved. So I hate to say sit tight on Damore. I will keep covering it as things keep coming out. But that's where we are with that one. Just so you know that it hasn't fallen off the radar either. I can't wait for Discovery. I think that's going to be just juicy and grand. But that's where we're at, guys. One more thing. I was going to do it in this video, but this video is long enough. But I want to say, in my last live stream, so that would have been Friday, what was that, the 19th or something? 17th, 18th? I don't know. Somewhere. Last Friday. Figure it out. I made some claims about copyright in regards to a podcast competition picture. And I made those claims stating that basically that the copyright for this would be owned by Capcom. I am going to, a matter of personal integrity, issue a retraction of some of that, and I do want to do a video kind of analyzing it a little further. I went back and looked at the Capcom art, and it is quite a bit different from the art that was actually used in this case. So it may actually be transformative, and in that case, the new owner could have a copyright in the transformative work. That doesn't necessarily mean that there's a legal claim there. And so I want to talk about that, and I'll probably do a supplemental video, but this is the next video I've done after the live stream. And it's a matter of my personal integrity to make sure I'm delivering accurate information. And upon some further research and discussion with a colleague, I think some of that information was not adequately delivered, and I apologize for that. But I'm going to make it right in a very soon upcoming video. As soon as I can lay out the argument as clearly as possible and bring up both examples. Because I want to let you guys know how fair use works, how transformative works are treated, and the difference between like a derivative and transformative work and stuff like that. So I want to make sure that I'm very clear on that. But in the meanwhile, it is possible that the person who did the art, which if I understand correctly, is actually not Maddox, may actually have a copyright in that is separate from Capcom's. So I apologize for my haste on that. I know I'm not supposed to apologize for things, but, you know, it looks like I may have gotten something wrong, so I'll be correcting that. Anyway, thanks for watching, guys. I'm going to wrap this video up. Stay tuned, of course, for that Cody Wilson interview. Stay tuned for my update on the copyright issue, update/correction, and stay tuned for any of these cases. If you guys have specific questions about some of these cases, get a hold of me on social media or wherever, that's fine, and just let me know, because I'm happy to answer those questions. If they're complex enough, I may do a whole video on them. You know, hoping to cover all of this stuff as it unfolds, but right now we're kind of in limbo on a lot of these cases. So anyways, thanks for watching, guys. I will talk to you soon. Have a good night.